Let me ask you something real quick. If your HOA sent you a letter saying they were going to foreclose on your home, the one you saved up for, the one your kids grew up in, all because of a $300 landscaping fine you didn't even know about, what would you do? I'll tell you what most people do. They panic. They freeze. They think this can't be happening. This has to be illegal. And then they end up writing a check and walking away defeated, convinced there's nothing they can do. But here's the thing. They're wrong, and I know that because it almost happened to me. My name is Marcus Webb. I live in a suburb outside of Dallas, Texas, in a community called Creekside Estates. And for the better part of 6 months, I went head-to-head with my HOA over a foreclosure threat. They slapped on my property over a $300 violation fine. A fine I never properly received notice about. A fine that had somehow ballooned to over $2,000 in late fees and legal costs by the time I found out what was happening. And today I'm going to walk you through every single thing I did, everything I learned, and more importantly, I'm going to tell you about the new 2025 laws that are changing the game for homeowners all across this country. Laws that your HOA does not want you to know about. Stick with me, this is going to take a minute. But if you own a home in an HOA community, this video could save you thousands of dollars or your entire house. I bought my house in Creekside Estates back in 2019. 3-bedroom, 2-bath, decent backyard, about a quarter acre, nothing fancy. But it was mine, and I worked hard for it. When I moved in, I signed a CC&RS, the covenants, conditions, and restrictions just like everybody else. I didn't read all 47 pages at the time. I know, rookie mistake. But honestly, I figured as long as I kept my lawn mowed and didn't paint my shutters neon green, I'd be fine. The HOA at Creekside Estates was run by a property management company called Summit Ridge Property Solutions. They managed about a dozen communities in the area, and they had a reputation. Not a good one. I heard stories from neighbors pretty early on. Vendor kickbacks, selective enforcement, board members approving their own relatives for contract work. But I kept my head down. I paid my dues. I stayed out of drama. Then in the spring of 2023, things started unraveling. I had a landscaping crew that came every 2 weeks. They were reliable, decent, did the job. But that spring, we had some of the worst storms I'd ever seen in North Texas, back to back, for about 3 weeks straight. My front walkway got some erosion damage. A little retaining edging crumbled on the north side. Nothing structurally serious, but it looked rough. I called my landscaper. He was backed up for weeks, the whole county was. Every lawn care company in the DFW area was slammed after those storms. I put in the service request, got put on the wait list, and that was that. What I didn't know, what I had no idea about, was that Summit Ridge had already been out to my property, photographed the erosion, and filed a formal violation notice against me. I never received that notice. Not in the mail, not by email, not by door hanger, nothing. And that's where this whole nightmare starts. Because under the CC&RS of Creekside Estates, if a violation notice goes unaddressed for 30 days, they can escalate to a fine. Fine goes unaddressed for another 30 days. They can add late fees and administrative costs. And after a certain accumulation threshold, they can, and I want you to hear this clearly, they can initiate a collections process and place a lien on your property. A property lien for a landscaping issue. I didn't find out any of this was happening until my neighbor Linda knocked on my door one Tuesday afternoon, holding a piece of paper she'd found taped to my mailbox post. She thought it was some kind of legal notice. She was right. It was a notice of intent to lien, and below that, in bold print, it said, if the outstanding balance of $2,148 was not paid in full within 30 days, the matter would be referred to their legal counsel to initiate foreclosure proceedings. $2,148. For a crumbled walkway edge I didn't know had been cited. I want you to understand what that moment felt like. Standing at my front door, holding that notice, my neighbor looking at me like she wasn't sure if she should stay or go. My stomach dropped. My hands started shaking. I'm not a guy who scares easy. I've dealt with hard stuff in my life, but this hit different. This was my house, my equity, my safety net. I called Summit Ridge the next morning at 8 a.m. sharp. The woman who answered was pleasant enough until I explained why I was calling. Then she got real professional, real fast. She told me the violation had been issued, the notice had been mailed, the cure period had passed, fees had been assessed per the governing documents, and my account now showed the stated balance. She said if I wanted to dispute the fees, I could file a written appeal with the board. I asked when the original notice was mailed. She told me February 14th. I never received it. She said that wasn't their problem, that under the CC&RS, notice by first-class mail was considered legally sufficient, and that failure to receive it did not nullify the violation or the subsequent fees. I want to stop here and say a lot of people would have just paid at this point, and honestly, part of me considered it. But something didn't sit right. Because I looked into it, I did the research. And what I found shocked me. First of all, the actual original violation for the erosion damage on my walkway, the fine was $300. That's it. $300, which given the circumstances of the storms and the contractor backlog, I absolutely could have argued was unreasonable, but even if I hadn't, I would have paid it. No problem. The other $1,800? That was all administrative fees, late charges, legal processing fees, and what they called a collections escalation surcharge. a charge that is not itemized anywhere in the governing documents. Second, I started talking to other homeowners in Creekside, and I found out I wasn't alone. There were at least 6 other residents who had received similar escalation notices in the past 18 months. Violations ranging from $200 to $500, inflated to thousands through layered fees. And here's the part that really got me. Every single one of them had paid. Not because they agreed with the fees, because they were terrified of losing their homes. This is how predatory HOA management works, folks. And I say that with full knowledge that most HOA boards are made up of regular neighbors doing their best. But Summit Ridge wasn't a volunteer board. They were a for-profit management company with a financial incentive to escalate violations and collect fees. And they had structured the process to make resistance feel impossible. I filed my written appeal. I documented everything: the storm timeline, the landscaper waitlist confirmation, my attempts to reach Summit Ridge, and the itemized breakdown of every fee they were charging me. I submitted it via certified mail to both Summit Ridge and the Creekside HOA Board of Directors. The board met. They reviewed my appeal. And then they sent me a letter, certified mail, ironically, informing me that my appeal had been denied, that the fees were valid per the governing documents, and that failure to remit full payment within 15 days would result in referral to their legal team. 15 days. I have 15 days before they sent a lawyer after my house. This is the part of the story where most people give up. This is the moment where HOA management companies count on you to just fold. Because the threat of foreclosure is terrifying, legal costs are real, and the whole system feels rigged against the individual homeowner. But I'd spent those weeks between my appeal and that denial letter doing something else. I'd been researching. I'd been reading. And I found something that changed everything. Let me back up for just a second, because I need to give you the context that makes everything else make sense. Because what I'm about to share with you, the legal landscape around HOA foreclosures in 2025, this is the part of the video that matters most. This is why I made this. For years, and I mean decades, HOAs across the country operated in what was basically a legal Wild West. States varied wildly in what they allowed. Some states had robust homeowner protections. Others had almost none. And because most homeowners never read their CC&Rs, never attended board meetings, never knew their rights, management companies were able to operate with near total impunity. HOA tried to foreclose on my property for a $300 fine. Here's what the new 2025 law says. That title isn't just a story. It's a reality that has played out in courtrooms and driveways across America. And for a long time, the law was on the HOA's side. But in 2025, that started to change. Dramatically. Here's what you need to know about the current legal landscape as of 2025. Number 1. Minimum debt thresholds for HOA foreclosures. Multiple states have now passed or significantly strengthened laws that set a minimum debt amount before an HOA can initiate foreclosure. In several states, that threshold has been raised to $5,000 or more in principal, not including fees. The HOA can still lien your property for smaller amounts, but they cannot push through a foreclosure unless the base debt meets that threshold. This is a massive change. Under older law, HOAs in some states could foreclose for as little as a few $100s. My situation, the $100 base fine, inflated to $2,100 through fees, would have been directly impacted by this kind of statute. Number 2. Fee stacking restrictions. This one is huge, and it directly hits the tactic that Summit Ridge was using on me and my neighbors. New legislation in multiple states explicitly restricts the types of fees HOAs and their management companies can charge during the collections process. So-called collections escalation surcharges and blanket administrative fees that aren't specifically authorized in the governing documents are increasingly being found to be unenforceable. Some state attorneys general have even indicated that charging such vague fees could fall under deceptive trade practices. Number 3. Enhanced notice requirements. This one is personal for me, because it goes right to the heart of how I got into this mess in the first place. You remember how Summit Ridge said notice by first-class mail was legally sufficient? Newer statutes in several states say that's not enough anymore. For violations that could lead to foreclosure, HOAs must now provide notice via multiple methods: certified mail, electronic notice, and sometimes even physical posting on the property itself. The old "we mailed it" defense is getting weaker. Number 4. Mandatory cure and repayment plan rights. Several states now require that before an HOA can move toward foreclosure, they must offer the homeowner a structured repayment plan. And once that plan is accepted, foreclosure action must pause as long as the homeowner stays compliant. This is huge for people who can't pay everything at once but can pay over time. Number 5. The right to a hearing before an independent panel. This is one of the most powerful shifts. In some states, homeowners can now request a hearing before a neutral third party, not just the HOA board itself. Because let's be honest, when the board is judging its own decision, it's rarely neutral.
Now here's the thing about all of this, and I want to be real with you, because I'm not a lawyer, I don't play one on YouTube, and your state laws are going to vary. What I can tell you is that the trend line in American law in 2025 is unmistakably toward more homeowner protection. And if you are in a situation like mine right now, the first thing you need to do is find out exactly what your state has passed or enacted in the past 2 to 3 years, because things have changed faster than most people realize. Back to my story. When I got that denial letter from the Creekside HOA board, I had already contacted a real estate attorney in Dallas. Her name was Patricia Sorrell, and she specialized in HOA disputes. She reviewed everything I'd put together, the violation timeline, fee breakdown, the appeal denial, all of it, and she told me something I'll never forget. She said, "Marcus, they made mistakes. Several of them. Some of what they charged you may not be legally defensible under current Texas law." Texas had passed significant updates to its property code provisions governing HOA enforcement leading up to 2025, specifically related to notice requirements, fee transparency, and the conditions under which a lien can be placed and foreclosure initiated. Patricia believed that the collections escalation surcharge Summit Ridge had applied and used on other homeowners was not explicitly authorized anywhere in the Creekside CC&RS, and that made it potentially unlawful. She sent a demand letter, 12 pages long. It outlined every procedural failure, every questionable fee, the inadequate notice, and the lack of an independent hearing. And it cited specific sections of Texas law. It also included something powerful. Notice that she was prepared to file a complaint with the Texas Real Estate Commission, and that she was already in contact with multiple homeowners facing the same issue. The response came back in 8 days. They backed down completely. The foreclosure threat? Gone. The extra fees waived. They reduced everything down to the original $300 fine. They even offered a payment plan. And in writing, they admitted there had been a procedural irregularity. It's a procedural irregularity, that's what they called it. I call it a system that finally got challenged. I paid the $300, and that was it. Done. But the story doesn't end there, because Patricia followed through and filed that complaint. An investigation was launched. Over the next few months, more homeowners came forward with similar cases. The findings? Summit Ridge was required to audit their accounts and address unauthorized fee practices. The Creekside HOA board made a big decision after that. They terminated Summit Ridge and hired a new management company. One of the first things the new company did: hold an open community meeting, something that had never happened before. Some of the residents who had paid inflated fees took legal action. A few of them won reimbursement. Others are still in the process. And me, I joined the HOA board. Yeah, I know how that sounds. But here's the truth. HOAs themselves are not always the problem. Unaccountable management companies are, and the only way to fix that long term is for informed homeowners to step in. Now let me leave you with practical takeaways, because this is where it matters most. First, don't panic. Panic leads to quick decisions and unnecessary payments. You have more control than you think. Second, document everything. Calls, emails, letters, keep records. Always create a paper trail. Third, read your CC&Rs. Yes, all of them. That's where your rights and their limits are defined. Fourth, learn your state laws. This is critical. States like Texas, Florida, California, Colorado, and North Carolina have made serious updates between 2023 and 2025. Know what applies to you. Fifth, talk to a real estate attorney. Even one consultation can change everything. Sixth, connect with your neighbors. If it's happening to you, it may be happening to others. Patterns matter. Seventh, understand the difference between a lien and foreclosure. They are not the same. Don't make decisions based on fear. Eighth, check if the HOA followed its own rules, because often they don't, and those mistakes can work in your favor. Now let's zoom out for a second, because this story isn't just about me. It's about something bigger. Across the United States, HOA laws are changing. Legislatures are stepping in. Homeowners are pushing back, and the balance of power is shifting. States are introducing higher foreclosure thresholds, stronger notice requirements, fee transparency laws, mandatory repayment plans, independent dispute resolution, and this trend is only growing. But here's the key point. The law only protects you if you know it exists. HOAs rely on silence, on fear, on confusion. Don't give them that advantage. When I got that notice on my door, I had two choices: pay quietly or fight smart. I chose to fight, and it changed everything. You can do the same. Your situation might be different, but your rights are real. And in 2025, they are stronger than ever. Don't let a small fine turn into a massive loss. Stay informed, stay calm, stand your ground. If this helped you, share it, because there are thousands of people out there right now in the same situation, and they need this information. I'm Marcus Webb. I'll see you in the next one.